My Lords, because both my own friends or Mr. Curl relied on Mr. Smith on questions of interpretation, I'll, if I may, reply to Mr. Smith first and deal with the interpretation. Yes. And first and foremost, could I ask you again to turn up clause 2.1, just to look at Mr. Smith's submissions on that. We agree with Mr. Curl, this is the most important clause. And just for your Lordship's notes, the submission of Mr. Smith as to what this means was at yesterday's transcript, page 96, line 15. There's no need to turn it up, I'll simply read out what he said. As to the interpretation of clause 2.1, he said, now, as a matter of straightforward language, that, meaning clause 2.1, releases any claim which a party has, firstly, against another party, and secondly, against an affiliate of any party, including its own affiliates. Now, my Lords, in our submission, that cannot be right. And just for the record, really, our submission on clause 2.1, both written and oral in the court below and written and oral in this court, is to the following effect. First, that clause 2.1 is the crucial clause, relating as it does to the release of affiliates. Secondly, that when you look at the words of the clause, any party has or may have against any or other may have against any other party or against any other released party. What we are suggesting, and what does least violence to the words, is simply to insert the definition of released party in the full words where the words released party appear. That has always been our case. And so the agreement reads, this agreement is made in full and final settlement of all claims any party has or may have against any other party or against any other parties and their affiliates. And it follows that other released party means other parties and their affiliates. We've always maintained that that is the most appropriate definition of it. It happens to accord with what we would say is the normal position, is that you don't release your own affiliates. And it cannot mean, we say, that released parties should be read as another party or any affiliates, as was suggested by Mr. Smith and adopted by Mr. Curl, because that wrongly detaches affiliates from the other parties to which they belong or are affiliated. And as we said before the judge, and we say before your Lordships, the possessive, their affiliates, just indicates no more than an affiliate belongs to a person. And we would suggest that when somebody is releasing a party, it includes their affiliates. And that's why the definition appears as it does. And we do no more than to introduce the full wording of the definition, which is 4 words rather than 2, in a conventional way. And we suggest that that works, it makes sense, and it leads inexorably to the conclusion that the parties did not intend to release their own affiliates. And what is more, when one then goes through the agreement, we suggest that the same technique of introducing the 4 words in the definition rather than the abbreviation released party or released parties works on each occasion to show that the parties did not intend that they be releasing their own affiliates. We accept that it is important in that way of interpreting the agreement that one assumes positively that the parties didn't intend to say that a party should, in any sense, release itself from a claim that it might have against itself. And that's why we introduce, as did the judge, the word other as it appears in various parts of the agreement before the word released party. Now, it is not necessary in 2.1 because the word other is already there, any other released party. But it is necessary, and we agree with the judge in clause 3.1. And we say that clause 3.1 is therefore aligned to clause 2.1 and means that each party agrees that, and then you insert the word other, the other parties and their affiliates are released and forever discharged from all claims. So, and our fundamental point throughout, it has not changed or be abandoned or in any way been diluted, is that is how you read this agreement. And crucially, you start with 2.1, which is the operative settlement. And everything after that is parasitic, and it works if you use that technique of simply putting in the 4 words rather than leaving the 2. And we very respectfully suggest that my learned friend's interpretation that they're urging upon your lordships of clause 2.1 does considerable violence to the language, and they don't really explain how they get there. The submissions that were made on clauses 3.1 and 3.2 were necessarily made on the premise that, properly interpreted, this agreement operated to release, for a party to release its own affiliates. Once one gets away from that concept, which we say the agreement neither stipulates for, and we also say would be highly unusual, it is not difficult to understand how clauses 3.1 and 3.2 work. And indeed, it's instructive that when one looks at 3.2 in the second sentence, it's plain that when the draftsman wanted to talk about a party's own affiliates, there's a special stipulation, its affiliates brings any proceedings. And the reason for that, we say, is because up to that point, there has been no release of one's own affiliates. There would be no need for any of that if they'd been released.
Sorry, I'm not sure I got that point.
Well, if we are right, and that there has been a full and final settlement, I'm sorry. I can see why you don't. It was I'm running ahead of myself. There is every need for the second sentence of clause 3.2. I'm so sorry, and it makes sense that it's there because up to that point you have not released the cast of thousands who are said to be your own affiliates from these wide-ranging claims. And so the draftsman then turns conventionally, we say, to the question, well, what do we do if an affiliate does bring a claim? And they addressed it. And in our submission, they addressed it because they were not released under 3.1, and no settlement had been made as between a party and its own affiliates in 2.1.
Can I just check one thing? Going back to your original skeleton in relation to clause 3.2, second sentence, you say that is to be read as each party will take all necessary steps to ensure that none of its affiliates brings any proceedings or asserts a claim against any other parties or affiliates of those other parties. And that remains your position, does it?
Yes. And that we're stuck with. I accept that. That's obviously all of this is on the premise that, contrary to our case, my only friends' clients are affiliates. But if they are affiliates, we say that's 3.2 second sentence is the conventional way, as is 3.4 of dealing with contribution claims, not a person releasing their own affiliates. And
yes, now you dealt with this in your opening submissions, and forgive me, but can you just remind me, on that premise, which of course you don't accept, but on the premise that they are indeed affiliates, what's your answer to 3.2? Because it says all steps necessary, and do you dispute that that would include discontinuing your claim?
What we do, because we say that it would be dealt with by a financial settlement.
It says including without limitation.
It does.
Of money, so it can't be confined to financial settlements.
Well, it does, but ultimately the recognition must be that if we've not been released, we're allowed on this basis to sue our own party, our own affiliates, on this premise. And what we must do is make sure that the bank's position is protected, which we could do in the way that I suggested in opening.
And remind me, how is that?
That was, in effect, what I said, I'll paraphrase, is that whilst we can't stop them, they can't stop us pursuing them, if it became clear that a contribution claim had to be made, we would admit a deduction from the compensation that we're due from our affiliates as a set-off or any form of netting, so that Barclays are assured of what they're due.
Okay, can I just follow up one moment longer? I know this harks back to the debate we had earlier on, but supposing that definitionally, say, the joint administrators count as affiliates, nevertheless, on your construction of the second sentence of clause 3.2, actually, you're not promising anything in relation to proceedings against the joint administrators, are you? Because all you're doing is saying that you will take steps to ensure that none of your affiliates brings proceedings against another party's affiliates. And the joint administrators would be your affiliates, and therefore clause 3.2 second sentence wouldn't bite at all. I'm looking at paragraph 25 of your skeleton because it sort of allows me to focus on how it would play out.
Yes.
And you say it should be read as meaning each party will take all necessary steps to ensure that none of its affiliates brings any proceedings or asserts a claim against any other parties or affiliates of those other parties. Now, the joint administrators, assuming that their affiliates would be affiliates of you, and therefore...
Yes, I see. I'm sorry. I'm with you now.
It wouldn't
you were ahead of me. Yes. Yes.
So it isn't just a definitional point about the meaning of affiliates.
No.
However, you construe affiliates on this construction of the second sentence of clause 3.2, there is no promise being made. in
No.
relation to.
No, and that is how we put it, yes.
But then that takes us back to the debate we had yesterday, which is on that premise, Barclays is completely unprotected, and yet you accept that it would be rational for a party in the position of Barclays to seek protection against ricochet claims.
Well, if in 3.4, you see 3.4 is when it says contrary to 3.2 above, that's the first sentence of 3.2, which is the one that deals with bringing proceedings. Each party agrees that it will not bring any proceedings against any, and we say other released party, in relation to a claim or otherwise assert a claim against any other released party.
I mean, that wouldn't bite either to proceedings against joint administrators. I mean, as I read it, on your construction, clauses 3.2 and 3.4 simply don't bite.
So I think that is our primary construction. The reason I'm hesitating is the second sentence of paragraph 3.2. Our primary, yes, paragraph 25 of our skeleton argument is our primary case on that, and that is right. If that is, then 3.4 would not bite.
Yes.
So, on your primary case, as you just expressed it, how does this settlement agreement protect Barclays against ricochet claims? The answer is it doesn't.
Well,
and how is that a rational construction from Barclays' point of view?
Well, it does prevent, it does indeed protect Barclays against ricochet claims, just not in the own affiliate sense. So if someone else's affiliate brings a claim, then it works.
It doesn't protect them against the very ricochet claim that was known to be in contemplation at the time of the settlement.
That's our point. That is our case. That's why affiliates should be read in that way as well. That's in a nutshell what we're saying. The one known case that we say it was acknowledged we would be bringing, it is accepted. It was the only lurking case that's ever been identified, which explains the way in which we've sought to rectify the agreement in our particular claim. It's all of a piece in that sense, because we have been operating on the basis that affiliates here covers Clyde Co and the joint administrators. We say, as you know,
So it comes down to this, that your proposition is that Barclays, in entering into this settlement, deliberately exposed themselves to a contribution claim from the joint administrators further down the line.
I wouldn't go that far. I would say that what was conveyed to us was in fact put into practice, namely that we would be able to sue the joint administrators and their advisors.
And that they would be able to seek contribution against Barclays.
If that's what they want to do, yes.
So far from achieving a clean break, Barclays were deliberately choosing to having all of this raked up all over again.
But this wouldn't come as a surprise to Mr. Schofield as a result of what he says with the nature and extent of his discussions with Barclays. That's in a sense what we're the subject matter of the dispute. He sits in the back of the court, and as far as he is concerned, he was told that it was a matter for him to go off and sue the administrators and so forth if that's what he elected to do, obviously on behalf of his companies. And it's with considerable surprise that he listens to the idea that this agreement is designed to prevent exactly that. But its only own affiliates in respect of which that operates. Insofar as other parties' affiliates are concerned, that's not the case.
I mean, just developing the point, it has to be a two camps version, doesn't it? Otherwise, well, the joint administrators are affiliates of two companies. Therefore, inevitably, they are affiliates of another party.
Well, we addressed that particular point, I think, in let me just get the, I think it's behind tab 26, but before we'll go there, let me just make sure I've got them. Yes, so I think we addressed that point in our skeleton, the supplemental skeleton behind tab 8. So it's forgive me, I'm not sure that is the. Well, let me paraphrase what we have got it in one of our skeletons.
I know you have got a two camps development.
Yes, I think it might be. Yes, paragraph. No, I'll ask Mr. Levy if he can.
I think maybe it's paragraph 33 onwards of your original skeleton. But if you take, say, clause 2.1.
I'm sorry, where is this now?
Sorry, if you go back to the agreement from
yes,
clause 2.1, and you've explained that on your case that's to be read as full and final settlement of all claims against any other party or against any other parties and their affiliates.
Yes.
I mean, of itself that won't do because the joint administrators are an affiliate of another party.
But then you get the capacity
in
argument.
respect of each company.
You get the capacity argument. The joint administrators, we would not be suing them. So one affiliate, one of the companies, would not be suing the joint administrators in their capacity as joint administrators of the other company. They're suing them as their own affiliates, not as someone else's affiliates. In each case. And that's the point that I'm sure is dealt with somewhere in a skeleton.
Yes, I expect you're right.
Yes, Mr. Levy has found it. It's in our main skeleton, which is why I couldn't find it. That's A56, paragraph 35.
Yeah.
And it's the last sentence. If, on the other hand, each of the settlement companies and Barclays is a party, the effect of the SA was not only to release claims by the settlement companies against Barclays, but also to release claims as between the settlement companies themselves. For all practical purposes, there's no difference in outcome on either basis. It's never been suggested there were ever any claims as between the settlement companies. As far as any one of the settlement companies agrees to release affiliates of any other, the releases of an affiliate is necessarily its capacity as affiliate of that other. This is consistent with the concept of an affiliate belonging to a party, in the sense that the settlement agreement treats as an affiliate as a party's affiliate or an affiliate of a party. Otherwise, whether a party released its own affiliate would, for no sensible reason, turn on whether that affiliate also happened to be an affiliate of another party. And so I think whether it's satisfactory is another matter, but I think that is an answer to my Lord's question.
Yeah.
That one is, whether it's two camps or four parties, we would suggest that paragraph 36 makes it clear that the, as it were, possessory nature of an affiliate is observed. And then, just staying with the agreement, my learned friend's submissions on clause 3.4, our case is that this really can only work as a matter of language and syntax on a two-camps basis. And my learned friend suggested that it works perfectly well on a four-party basis. He didn't address, and could I just remind you that clause 1.3, which lumps together the settlement companies as having joint and several liability effectively to themselves and Barclays.
Don't quite get the basis for your submission that defeats treating them as four parties as opposed to two camps. I could understand the submission if it said the obligations of REL, REPL and Askwith contained in this agreement are joint, but it says joint and several.
Yes.
So,
my lord, it's maybe my fault.
How then do you say that they don't have distinct liabilities?
That's not so much that, my lord. It is that within clause 3.4, given that they are jointly and severally liable in respect of their obligations, if each one of the settlement companies is treated as a party for the purpose of 3.4, you will end up having circular obligations. Because every time one is indebted to the other in respect of either claims between them or claims between them and others' affiliates, the ultimate indemnity and payment will be circular because they're each jointly and severally liable to each other. Whereas on a two-camp basis, that's not a problem. And as you know, we made it clear that clause 1.3, we say, is an important part of the way in which one needs to look at how this agreement was intended to operate. And you have to bear in mind at all times that within the settlement companies, there is this joint and several liability, even as between each other. And we say that that's a strong indication of the two camps approach, which mirrors the situation in the litigation. Moving on to Mr. Smith's submissions on the definition of claims. Mr. Smith first relied on the fact that there's a specific carve-out of one claim at the end of the definition of claims. And you recall made submissions in reliance upon the way in which we are seeking to rectify this agreement by the addition of a second claim. That's what I'm addressing now. But first of all, we say that there's no need to carve out the claim because the settlement agreement didn't release it. But, and that's the point in Heaton, which we relied on. And my only friend's answer to that is that Heaton is dealing with a different type of situation. But our answer to that is that Heaton was expressly, according to Lord Bingham, as we've shown you, construing an agreement and staying within the four walls of the agreement just to see how it operated, and then interpreting it by reference to the extraneous material. And in that process, as you know, Lord Bingham said that there was no need for the one party to reserve a right to do that which the other party can do in any event. And my Lord, a submission was made that what we are now saying in our rectification claim is, as it were, to be interpreted as somehow undermining our claims on construction. We disagree entirely with the suggestion that the way in which we are seeking to rectify the claim, the settlement agreement, is in some way inconsistent with the case that we're running in this court. We say, as you know, that the settlement agreement did not release claims against the Malone Friends clients, and by the rectification, all we're seeking to do is to correct it to allow such claims. It doesn't detract from the fact that we interpret, for our part, the document as not affecting internal releases. It doesn't try to rewrite to accord with the party's intentions the various aspects of it, because we don't need to. In one sense, all we need to do is ask to rectify this agreement so that there's a recital that makes it plain that the parties agree that the claims against Malone Friends are not affected by the agreement. That's all that would be required. The technique that we have chosen is to add a second specific claim to the end of the definition of claims. But whichever technique we use, which is meant to be the least invasive in order to reflect the particular relevant intention, it doesn't in any way have an impact on how we are arguing for an interpretation of this agreement in this court.
Well, what do you say to this? I quite understand, obviously, that your rectification claim is taking as its premise that which you dispute in this court, namely the two construction of the existing settlement agreement. Obviously, one starts from that position. However, what one notices is that the way you seek to rectify the agreement, if you're wrong on the construction, is not by tinkering with the definition of release parties, nor is it by tinkering with clause 2.1 or clause 3.1, for example, by adjusting the wording to make it clear that, as you say, the intent of the parties was that it should operate in a two camps manner. On the contrary, the proposed way in which you seek to rectify it leaves all of that in place, but instead creates a carve-out for a class of claim that was known to exist as at the date of the settlement agreement.
Oh, yes.
Why is that not somewhat inconsistent with the way you're arguing the case on construction?
Because, my Lord, in the events which have happened, all we want is to be able to continue the proceedings against the administrators and Clyde Co.
I appreciate that's all you want, but your case on rectification is there's been a mistake. The document as drawn doesn't reflect the true intentions of the parties. And you say the true intentions of the parties were that it should operate on a two camps basis.
Yes.
But that's not what your proposed rectification does. It simply creates a carve-out.
But my Lord, however one looks at it, if the agreement as signed had simply added the second sentence that we're proposing to insert by way of rectification at the end of the definition of claims, there would have been no difficulty, because as far as we are concerned...
To be sure, but that's the point I'm putting to you. In other words, what it comes to is this. If you get your carve-out, you're perfectly content for this agreement to operate as it is said to operate, namely in respect of both opposing parties' affiliates and own parties' affiliates.
Absolutely, my Lord. And that's just being pragmatic, I'm afraid. I'm sorry. That is exactly our position. But ultimately, we are saying the intention was to make sure those claims were not bound by this, and that's an end of it. There are now many words in this document which one could, in a rather sort of painterly way, try to tinker with, but ultimately, the rectification that we seek is to reflect the fact that we say the parties intended to carve out those claims. And we don't shirk from the fact that that is, in a sense, not as pretty as trying to match the rectification to the submissions that we're making in this court. But what we do say is that there is no inconsistency there. This somehow detracts from what we say this agreement means as drafted, which is a different point. So we're concentrating very much on remedies as far as rectification is concerned. Now, a remedy would reflect the intention of the parties. I'm sorry to labour the point, but we just believe that the cleanest and simplest way of rectifying it is in the way that we have suggested. There may be a cleaner and simpler way, but the understanding is that the cleaner and the simpler the better, so long as it reflects what the alleged intention is said to have been, which was omitted from the unrectified agreement. Turning, if I may, to a new topic, then responding to Mr. Smith's submissions on the question of whether the administrators were agents stroke officers. And I'm not going to repeat any of my submissions on agency in that respect. You have them, and I respectfully suggest that nothing that Mr. Smith said impacted on that. So far as his submissions on officer are concerned, we have always accepted that for some purposes, administrators can be designated or characterised as officers. And we have also made it clear that in some respects they are not. What actually matters is what these parties thought that they were saying in this agreement. And to bring in a raft of authorities, all decided in different contexts in relation to often different statutory regimes, is in a way to deflect one's attention away from the real question, is what these parties thought. And you've got my submissions on that. I'm not going to repeat them. This is simply by way of reply. We say that is the relevant inquiry in circumstances where the JAs had been identified, had been spoken about, indeed no one other than the JAs had been spoken about as relevant third parties. And we say that these parties in this agreement would not have dealt with it in that way. Moving on to the next topic, the next section of Mr. Smith's submissions related to or addressed the admissibility of Mr. Schofield's second witness statement. I hope this isn't unfair to him, but the way we received his submissions on this was that he only addressed one half of the relevant part of Mr. Schofield's evidence. The important part of Mr. Schofield's evidence is not his refrain over many meetings, including the mediation, that he wanted to sue the administrators and their advisors in due course. The important part is Barclay's response to the effect that they were not claims against Barclays and that he should bring them against the joint administrators and the advisors. That's the bit that matters. And we say, as you know, that that fact was in the common knowledge of the parties at the time of the signature of the settlement agreement. And that you can't cherry pick Mr. Schofield's evidence and sort of splice it up and admit the fact that he repeatedly said that he wanted to sue them, but ignore the fact that their response, he says, every time, was that that was a matter for him and he should take his own course in due course. And so when you look at Mr. Smith's submissions, we're asking you to bear in mind it's the second part of Mr. Schofield's evidence which is important, not the first.
Well, his point about that was that that was in evidence of Barclays' subjective intention not to release the administrators.
Well, may I just come straight on to that in that case? He did that, I think, by criticising the phraseology in paragraph 61 of our skeleton. And in that respect, if you just turn that up, I think it's at page A65. Where we said the evidence was not of negotiation or subjective intention, but of objective fact as to the existence of a common understanding and agreement. And he said, now you're straying into inadmissible country, if I can put it that way. But we stand by that phraseology. And you'll recall that in the Supreme Court in Oceanbog, they were unanimous in agreeing with Lord Clark, who in turn was setting out Lord Hoffman's relevant part of Lord Hoffman's speech in West Bromwich, that you can have evidence of what was said or written in the course of without prejudice negotiations, and that they are in principle admissible, not just when the party is considering rectification based on a common understanding, so forth, but also when the court is considering a submission of the factual matrix relevant to the true construction of the settlement agreement includes evidence of an objective fact communicated in the course of negotiations.
I mean, there are two different issues out there. One is it a problem where you have a communication in negotiations. The other is it a problem where you have a communication, whether or not in negotiations, which is a communication of subjective intention. And your Oceanbelt point deals with the first rather than the second.
Well, the intention, there are two different things here. What Barclays said and what we say became, therefore, for these purposes, a fact in the world, was that Barclays had consistently told Mr. Schofield in the course of the negotiations and previously that complaints regarding the administrators were absolutely not for Barclays to deal with, and that he should instead take action against the administrators and their advisors. That's the fact, as it were. There's nothing to do with intention. The question is how that fact then is used when undertaking the objective assessment of what the party's intentions were.
What is the fact? The fact is, do you mean it is objectively the fact that any claim against administrators has to be brought against administrators?
Well, it's the same as in terms of categorization, it's the same as the four representations in Oceanbog. They are representations made in the negotiations, which becomes an objective fact for the purposes of feeding into the process as to what the intention of the parties was by reference to the words in the contract.
Not quite sure I follow. Do you mean it is an objective fact that
that's what we were
in the
told
real world, rather than what Barclays thought?
Yes.
If any complaint about the conduct of the administrators necessarily could not come home to Barclays?
No, it's more than that. It is, as he says, that it would be for Mr. Schofield thereafter to sue them. He's being told that by the Barclays in the long period leading up to the mediation and at the mediation.
And what does that mean?
Well, it means sorry.
If he hasn't issued proceedings yet, he's got to issue them in the future, or what?
Well, he's free to. I mean, that's the point. It's highly relevant when asking oneself, did therefore the parties intend that he would release the administrators in this case as their own affiliate, a few hours later when he signed the settlement agreement. That's what's relevant to.
I mean, do you mean Barclays meant that they wouldn't expect the settlement agreement to preclude claims against the administrators?
When asking whether the parties intended, I think is where I'd put it, when asking whether the parties intended that it should, you take into account those discussions which plainly contemplated that that those claims would take place at a later date.
I'm just trying to understand what the fact is. The fact is that Barclays does not expect the settlement agreement to preclude claims against the administrators.
The fact is that they told us that it would be for Mr. Schofield, this is the fact, the representation was, it's for you, as we have always told you, to sue them.
And
Nothing to do with us.
What does that mean as an objective fact?
Well, it then is, it feeds into, if that is what was said, and one always assumes that obviously the parties are being honest and transparent, that's what ocean bulk is all about, then the court will take that fact on board when asking what those same parties intended by using the words that they did, which are in dispute.
So if we're taking that fact on board, what is the fact that is communicated?
That on the one hand, Mr. Schofield had identified that he was going to sue the administrators and their advisors. And on the other hand, the bank, prior to and at the mediation, was saying, well, that would be a matter for him to take up with them.
So the fact is that any claim relating to the administrators must be brought against the administrators.
Yes. And on the basis that that was what was being said, one then asks, what relevance does that have and what weight does it have when assessing the words that they used in the settlement agreement? That's as I understand what I might call the ocean bulk point. I mean, the ocean bulk was about representations made in negotiations leading to the settlement agreement. And that leads me to the last point, I think, made by Mr. Smith on Schofield 2, to which we would like to respond briefly. And it's this. You may recall that he took you to the decision of this court and the judgment of Lord Justice Mummery in the case of Datani. And he then sought to distinguish Datani as a case where there was no written agreement. Now, we accept that in Datani there was no detailed written agreement, but it does not explain reliance placed by this court on the passages in Foskett, which you've seen, which expressly related to admitting extrinsic evidence to identify the disputes which the parties were endeavouring to settle in a dispute about a settlement agreement. And if Datani was to be regarded as a case about an oral agreement, then the parallel evidence rule wouldn't apply anyway. Plainly, Lord Justice Mummery, we would say with very great respect, correctly, was operating on the basis that the parallel evidence was in play, but he brought Foskett to the rescue and effectively applied the rationale in Foskett to the facts of the case that the courts had before them. And that was, in other words, to have regard to extraneous matters in order to identify the scope of the dispute which the parties were endeavouring to settle. And your lordships may recall I took you to Mr. Justice Jacobs in the Global Solutions case, and it's clear from his decision, for the reasons that I gave, that not only did Mr. Justice Jacobs, in a case which plainly involved an all singing and all dancing settlement agreement, regard the principle in Foskett as applicable, but he also applied it. On the facts of that case, he found that the agreement was clear. But nevertheless, he went through the process of admitting the evidence based on what we might call the Foskett principle in a case which involved a full settlement agreement and the construction of it. Moving next to rectification. It's with some surprise and dismay that we learn that it's now been said that we should have brought the rectification proceedings earlier, and somehow that will count against us. Could I invite you to take up the core bundle behind tab 9. That should be a chronology, on the second page of which A144. You will see that claim form and the particulars of claim. Well, I'll start. If one goes to the 5th of July 1919, that's the beginning of the misfeasance proceedings. And then the 5th of July 1919 is also the issue of the Clyde Co proceedings. Clyde Co proceedings, and that was at the end of the limitation period, or certainly arguably the end of the limitation period.
And the limitation period is 6 years for this purpose.
Yes. And the Clyde Co proceedings were immediately stayed because we needed to go through the statutory filter for misfeasance proceedings and made an application for permission, which came before His Honour Judge Simon Barker. And you see there, the 3rd of September 2020, he granted permission. And we'll come back to the statutory permission shortly on a different issue. And then you'll see that on the 8th of September, Barclays provided Clyde & Co. with a copy of the settlement agreement, subject to agreed terms as regards confidentiality. And the particulars of the claim were then served. What's not on this chronology, but was in evidence, is that on the 29th of September 2020, we wrote to a long letter to Barclays, enclosing copies of both sets of particulars of claim, both in the misfeasance proceedings and in the Clyde & Co proceedings, and asking for permission to, in effect, show the full terms of the settlement agreements to both Clyde & Co and the administrators. And in broad terms, that was agreed subject to terms. You see that on the 11th of November 2020. And then the application came in suggesting, on the 18th of November 2020, suggesting, amongst many other things, that the settlement agreement affected internal releases.
Presumably you would accept that at that point you could have issued rectification proceedings against Barclays.
Well, we could, but I'd invite you just to reflect.
Can I just get an answer to that question before we move on? So the answer to my question is yes, you accept you could have issued rectification proceedings against Barclays at that point in time.
My lord, yes.
Right. So then we move on to the should you have.
Yes.
And the case that's put against you is not only could you have, but you should have.
Yes.
So you're about to tell me why you shouldn't have.
My lord, I am. First, at no time did Barclays suggest to us that what we were doing was in breach of the settlement agreement. It had a full set of particulars of claim in both proceedings. It was well aware of what was happening, and there wasn't a moment when it was suggested by Barclays that we were somehow in breach. On the contrary, they asked us to obtain or procure confidentiality agreements from both the joint administrators and their advisors and Clyde Co.
So far, this point seems to be against you, because we have a scenario whereby a settlement agreement has been disclosed with Barclays' consent, and there is a strikeout summary judgment application on the strength of the settlement agreement, and you say at that point, Barclays have given you no reason to think that the settlement agreement meant anything other than what you said. And therefore, as at that point, you had no reason to think that a rectification application would not be consented to. So why didn't you do it?
Well, at that stage, as my Lord knows, we took the view, which we assumed Barclays was taking at the time, that the interpretation that was now being advanced based on internal releases was just plainly wrong. And we knew that if we joined Barclays into the proceedings, the interpretation issue would have to be determined come what may. Because one would always determine first what the agreement says before one decides whether it needs to be rectified. And so that's precisely what happened. The judge, in his judgment, informed the parties of what it said. And it could be said that immediately after we got his judgment, we should then have issued proceedings against Barclays. The difficulty with that is that the proper thing to do would be to join Barclays as a third defendant or second defendant, speaking loosely, in each set of proceedings, not so easy in the misfeasance proceedings, somehow bring them in as parties and commence the rectification proceedings. However, all of that would have been postponed pending the outcome of these appeals. No one would be in any better or stronger position.
I'm sorry, I may have missed it. I'm not quite sure what your answer is to the question I was asking, which is, if Barclays agreed with you that the agreement was not intended to stop these claims, and therefore were agreeable to the carve-out that you're now seeking.
Yes.
And your submission was, at that point in time, you had no reason to think otherwise.
Yes.
What was stopping you doing it?
Well, we didn't. Of course, I accept that we didn't. It turns out, in fact, that we were right. Because, of course, Barclays...
It turns out you were wrong, because Barclays don't agree.
That's what I mean, that we were right not to ask them. Because they would have said no, and we would have been in no different position today. Because we still had to have the dispute and the hearing and the determination of the proper interpretation of the agreement. That always had to happen first, logically.
But it didn't all have to happen in the absence of a rectification claim, at least on the stocks. Because you could have said to the judge, if you'd done that, well, stay your hand on this, because Barclays might agree, or if they don't, we might succeed in persuading the court that the meaning that you arrive at, if you're against us, is not the true meaning of the agreement, or it didn't give effect to the party's intentions.
However one looks at it, my lords, nothing would have happened on the rectification side, if I can put it that, and ignoring the procedure for a moment, unless and until this court had given judgment.
Because so, but you might have persuaded the judge of first instance that he should not strike out the proceedings because there's a pending claim in the alternative for rectification, which would sort the whole position out.
Well, he knew that rectification, he basically said to us, part of his judgment, I don't agree with your interpretation, and I think rectification is the fair answer for you. That was the gist of his judgment. If you're right about what you say, then rectification is the fair answer for you. And in the events which have happened, we have since issued the rectification proceedings, but it was inevitable that we were going to wait until the outcome of this appeal before anything meaningful could happen in those proceedings. So I would suggest, although it is easy with hindsight to to criticise us.
So that submission seems to me suggest that your issuing of claims against Barclays is, in fact, still premature.
We have issued because we were being criticised by our opponents for not having done so.
But your position, as just articulated, is that the decision on this appeal always has to come first. So why is your claim against Barclays not premature on that hypothesis?
As I just said, my lord, we received skeleton arguments from my learned friends. It was plain they were going to make a meal of the fact that we hadn't issued rectification proceedings, and so we have done so. That is the straightforward answer, I'm afraid.
Even though on your case it's premature.
Well, I can't win either way on this basis. I'm damned if I do and damned if I don't. I mean, I can't take that any further. I'm criticised if I don't issue them at all. On one view, I should have issued them a long time ago, but to no actual avail. And I issued them, in fact, somewhere in the middle, and I'm still criticised.
I understand why you say what you've just said, but let me put the point one last time. The case that's put against you is that you should have done this before the hearing before the judge. And it said it's too late after the judge has given judgment. Now, if that's right, you can't meet that by issuing claims before this court has given a decision. But if your answer to that allegation is logically correct, namely that construction has to be done and dusted first, then in fact, the strength of that logic would mean that you didn't have to have issued the proceedings when you did. And in fact, you issued them prematurely.
And my lord, we virtually say as much in our supplemental skeleton. We say we have only issued we were going to wait. We've only issued them now because we're being criticised.
The reality is the fact you have now issued is irrelevant.
Well, that's
because the logic of your position is you didn't have to issue at any point in time until there was a final decision on construction, if need be in the Supreme Court.
But my lord, this sort of thing is not a chess game, which I'm rapidly losing. This is more just being pragmatic. You know, all that we were doing is responding to a suggestion that in some way we're culpable for not having done so. And it's a pragmatic response, and we've said as much in our skeleton arguments. I respectfully suggest it's not fair to hang us by our own petard there and say, well, that's illogical, and therefore I treat it as irrelevant.
Can I just try it a different way a moment? Going back to the autumn of 2020.
Yes.
You get in applications relying on the settlement agreement.
Yes.
In which I think contentions broadly along the lines the judge has ultimately accepted.
Yes.
Are put forward. Mr. Schofield obviously subjectively thinks that whatever the correct interpretation of the agreement, that isn't what was intended. And by this stage, you're also doubtless conscious that if you have to bring new proceedings, they're going to be too late. So you've got to ensure that these proceedings live on.
Yes.
And then there's a directions hearing at the beginning of December 2020. I mean, wouldn't that have been the right time to think we better do something about keeping this rectification claim alive or raising the rectification claim so that we don't run the risk of finding it's all too late?
Well, it might. That's with hindsight, and it's a counsel of perfection. I think the only point I'm making is it hasn't actually, in fact, made a difference.
Well, it has in this sense that supposing that ultimately we were against you on interpretation now,
yes.
That would be the end of the story, absent the rectification claim. Whereas, as I understand it, you say, well, now resolution for the defendants has to be postponed for as long as it takes for the rectification claim to be fought out.
Well, we do. It's a ground of appeal of ours that we say that the proper approach to this, having regard to the fact that rectification was in the wings, was indeed not to deal with any of this now, but to deal with it all together at the end of the trial. That is one of our so.
Well, as things stood, it was impossible to deal with this at trial because there wasn't a claim for rectification.
But it's on the premise that the judge, having found in his judgment that actually, in my judgment, he says this is a rectification country, as it were. We've then got first instance careful judgment telling us that our interpretation is wrong, then a friend's interpretation is correct, and telling us that rectification is the route. At that stage, there's the choice. We either ask the Court of Appeal to consider the interpretation point, or we start the rectification proceedings. It doesn't actually make a difference in real terms, other than, and I accept this, ultimately I would be asking you, if you're against us on everything, save this point, if I can put it that way, to allow the appeal only for the purposes of staying the proceedings, but otherwise, as it were, agreeing with everything the judge said.
So the logic of that position is that you could have appealed purely on that ground. You say that you could have appealed the judge's order, not on the strength that anything he said in his judgment was incorrect. On the contrary, you would have accepted every word of his judgment, but you'd have said, we are going to issue rectification proceedings, and therefore, even though the judge's judgment was correct, his order was wrong because it shut us out forever and a day, even though we had an intention to bring rectification proceedings and brackets well after the expiry of the deadline for filing notice of appeal, we've actually done so.
Look, we could, but of course we did want, and still want, the opportunity, this court, to deal with the interpretation. But that's something that Mr. Schofield feels strongly about. He wants this court to assess the judge's judgment.
We're concerned with the effect of the claim for rectification. And I think you're accepting what I'm putting to you, namely that if, contrary to the reality, you had accepted the verdict on construction, you say you could still have appealed anyway.
Well, we could have done if we had. The difficulty, I think, with that is that if we hadn't had, having obviously considered the judgment, a settled intention to appeal, we probably would have asked the judge for a stay.
Can I put another point to you? Sorry to prolong it, if I'm not interrupting your debate with my lord. It's occurred to me that one way it might have been looked at before the judge, in a theoretical world, is that although if the court concluded that the claim had no real prospect of success, there was nonetheless another compelling reason why it should be disposed of at a trial, namely to allow the resolution of all these issues in a single set of proceedings. Would that, and that's not what actually happened, I think.
Well, yes.
Because the light bulb in relation to rectification didn't come on until later on. But,
well, my lord, in grounds of appeal at 4C, we do say the correct. Sorry, this is page A17. A17. At C, it would have been inappropriate on a strikeout or summary judgment application for the court to determine the interpretation, or to do so pending determination of any rectification claim which may be made by a party to the settlement agreement.
yes, I'm really exploring the procedural framework within which that might have been done.
Yes.
I think that's the point you're now making.
But, my lord, it is, and we are simply saying that in circumstances where the underlying proceedings are time barred, if we have to start again, as it were, it would be fundamentally unfair to maintain the claims are struck out, because that would render the rectification claim redundant. There would be no point in it, and that would be the end of the road for Mr. Schofield.
Say possibly against the administrators if the ex parte James principle disabled them from relying on limitation.
I was being a bit clunky. I was assuming everything against myself just to have the debate.
Yeah.
I'm assuming you're against me on absolutely everything. But yes, if that would be a different issue. I noticed the time. Could I move on to ex parte James and deal with that relatively briefly, I hope? My learned friend, Mr. Smith, made some detailed submissions on ex parte James. The fundamental difference between us, if I can just try and articulate it this way, is this. He says that it's too late, we're no longer officers, and this is not something, as it were, that we have done. We're just trying to take advantage of something that has happened after we have left office. And he says there's no legal context in which the court can now exercise its supervisory function over these individuals. I think the short answer to that I would offer you is to take you back, and I appreciate that you know this provision, but can we just go back briefly and look at the Insolvency Act? You'll find that behind tab, I think it's 8, and the particular provision, obviously, which is very familiar, is paragraph 75, C129. C129. Now, under paragraph 75, this is Schedule B1 to the Insolvency Act, the court examines the conduct of its former officer, during the period of office. And the question arises whether an administrator can avoid that examination by relying on a release of the nature that we have in this case. And so far as we are concerned, a claim under paragraph 75 is a claim which remains within the process or within the administration of the estate, where the administration remains under the supervision of the court, subject to the statutory filter, because an applicant who is a contributory needs permission. But having got permission, the court exercising its jurisdiction over its former officer, looking at its conduct during its time in office, and we say that the court has the ability to control the administrator's conduct in that context. And we accept that the test in Lehman, namely that the court will not permit its officers to act in a way that would be clearly wrong for the court itself to act, is applicable, paragraph 68 of Lord Justice Richard's judgment. But it would not be difficult to think of circumstances different from ours, where if it is known that the release in question is, let's just say, possibly fraudulent, would it be right that before that question is determined, the court would allow the administrators to bring to an end the application to have their conduct examined?
Rely on a fraudulent release anyway, so
No,
the question wouldn't arise.
Oh my lord, I'm not suggesting that it has been determined to be fraudulent. This is just a timing issue. Would it be right, in circumstances where it is alleged that the release is fraudulent, to allow them to rely on it pending determination as to whether it is? Just to test the point. It's the timing point. And I would suggest that it is not correct to say that the court at that stage is, as it were, functus vis-à-vis the administrator for the purposes of the ex parte James rule. If the court found circumstances which would otherwise offend the rule were present, notwithstanding that they are no longer in office, our submission is that the rule would be applied. And it's the special nature of paragraph 75 which shows the court, notwithstanding their discharge, to be examining their conduct with a view to making restoration to the estate or directing a contribution and so forth. Again, putting right the administration, as it were. And our submission is on the blanket point that's made about timing. The fact that they're out of office would not mean that the rule is either not applicable or
You emphasise
disengaged.
once again the timing point, but you haven't answered the submissions made against you by Mr. Smith, which is, if it's all about timing, then the point at which you test it is when you invoke the limitation, or when the limitation defence is invoked. What do you say to that?
Well, we don't say it's got anything to do with limitation.
You say it's all about timing, so how do you square those two propositions?
The timing that I'm referring to is the fact that they're no longer in office. That's the timing point referred to in the skeletons. My fault. I should have not have had such an abbreviation. That it is said against us that the ex parte James simply can't apply at a time when they're out of office. It only applies whilst they're in office. That's the first point that's made. And we're saying that can't be right. Because in particular, paragraph 75, life goes on, as it were, for the purposes of the administration, if you have paragraph 75 proceedings. The second point that's made is that there is, I think, is that there's currently no unfairness. And as far as that's concerned, we say, well, in a sense, you've got to wait to see whether there is unfairness. And it's not right to snuff that out now. Because if in due course it turns out that the agreement should be rectified, then these proceedings should not be struck out. And we say that it would be wrong in an ex parte James sense, objectively unfair, to enable the administrators to gain the benefit of the settlement agreement if in due course it turns out that that benefit is not there. That, in that sense, it would be wrong for them now to rely on their strict legal rights, having regards to the principles in ex parte James. Moving on, and that's all I wanted to say by way of reply to Mr. Oh, I'm so sorry. There's one more point on ex parte James. Danger of doing this too quickly. Mr. Smith made submissions to the effect that the statutory scheme for bringing misfeasance proceedings against administrators is not in any way violated or does not prevent the administrators from accepting releases from such claims. And our case is that there is a clear statutory scheme which envisages misfeasance proceedings surviving the discharge of liability of administrators. And the statute also provides that people in the position of my clients require the permission of the court to issue paragraph 75 proceedings or a claim after discharge. And our case is that you cannot contract around that.
I wonder whether you have to be a bit careful there, because you're not suggesting that it is possible to settle proceedings. I mean, suppose you'd written a letter before action, and instead of the proceedings being issued and then settled, the joint administrators had said, well, you've got a point, but we're going to pay you very little. We'll pay you £1,000. Would that have offended anything?
No, you can always settle proceedings. What I'm suggesting that you can't do is introduce a new procedure for being released from any claims. Because the statute releases the liability, the administrators from liability, subject to some conditions. The only relevant one is that a misfeasance claim can be brought with permission in certain circumstances. So the question that arises is can you simply contract out of that?
So take it by stages. So suppose you write your letter before action. The joint administrators write back something very convincing. Trouble is, there has to be a contract. So they have to give you something, even if it's only £1. So they say, we'll give you we think we want finality. We think there should be a written document recording that you abandon all your claims in return for £1. Is that effective?
Well, it depends whether that's it's not it's effect. I don't know what one's settling at that stage.
No. All right. Well, let me put it slightly differently. Suppose you write your letter before action to two people, the joint administrators and a creditor.
Right.
And the creditor, they write back saying, you've got to withdraw all your claims against the administrators, but we'll pay you a sum of money. Is that objectionable?
Well, that's
more or less this case, of course.
Yeah, that's a compromise of paragraph 75 proceedings, just an ordinary settlement. I mean, this is of a different order. I mean, this is purporting to release the administrators from, or in fact, to impose a different regime than the statutory regime for releasing them from claims.
Yeah.
And we just say it's inconsistent with the statutory scheme to have that. It's quite interesting that in over 150 years since misfeasance proceedings have been on the statute book, certainly against liquidators, there hasn't been a case that we can find anyway, not giving evidence now, about such a release. Turning then to Mr. Curl's submissions. He made detailed submissions about what he called his gateway point, namely that you can't be half in, half out. I can't remember now, I think it's biblical. You know, he says once you pass through the straight and narrow gate, you're in, as it were, and no amount of some of your capacities being non-agency will get you back out again. He said, once you're in, you're in. And it was suggested that that's the only way in which there can be certainty. Now, my lord, I'm not sure that's right. I mean, on his assertion, you can have a person who, as it were, may or may not have been an agent for a day, but for the other 10 years was certainly not an agent. And he says he's got his foot through the gate and that's all that matters. It cuts both ways. And it's not a good touchstone for working out how the section, how the clause works. We say that on this, the judge was right, that you do have to be, come within, whatever it means, you still have to come within the section, the clause, I'm sorry. You still have to be an agent, whatever that means, in respect of the activities which give rise to the claim. And that if you've got persons who do both, if the judge is otherwise right in his interpretation, then he was right to identify that the solicitors are not within and cannot have the benefit of settlement agreements insofar as they were acting as something other than agents.
Why is that not simply ignoring the words in whatever capacity?
Because, as we said in our submissions, you can't use the words as they appear in the definition of liability to alter the definition of affiliates. It's an extension too far. And no one could sensibly have thought, we say, that because of the words stuck on the end there of the long definition of liability, that would have an influence on who the affiliates were.
It's two different questions, isn't it? One is, who is an affiliate? And you look to the definition of an affiliate to find that out. And once you find out that they are an affiliate, the next question is, what is the scope of the release? And you find out the scope of the release inter alia by looking at the definition of liability. That includes in whatever capacity.
Yes, and as you know, our submission, and you were taken to it by Mr. Curl, is that the question of claims does not impact on deciding whether or not somebody is an affiliate for the purposes of relying on the release.
Well,
so you can rely on...
So I'm accepting that proposition for the purposes of this discussion. So yes, let's assume that it doesn't in any way affect the definition of affiliate. Well, surely what we're concerned with here is the scope of the release. And why does it not affect the scope of the release?
Because we say that you're only released insofar as you're an agent, and that the definition of claims doesn't affect that proposition. That's our case in our skeleton. It'd be quite impossible otherwise. And it goes back as an example, the person, therefore, who's an agent for the day, in a 10-year pattern of conduct, is released in respect of the 10 years. That just doesn't make any sense. If he's an affiliate in a tiny respect, if I can put it that way, he can't be an affiliate in every respect. So we say that the judge was right on the assumption that he was otherwise right. He was right to make the distinction that he did. And it's instructive that Millennium Friends said that, well, a solicitor who's solely advised would not be an agent. And you can imagine a solicitor-client situation where the solicitor solely advises for 5 years. And on one occasion, he acts as an agent. That apparently would make him an affiliate. And that just is not logical or coherent, we would say. In the context of Mr. Cole's submissions on capacity, there was a debate this morning about the rival paragraphs or differing paragraphs in the judgments of the judge. I think it was, if we go to his judgment behind tab 12, which was comparing paragraph 98 to paragraph 165. And there were strong suggestions in this context that there was tension between them, if not a degree of irreconcilability. And having listened to that debate, can I just suggest that as far as paragraph 98 is concerned, the judge was dealing with a different point here. And as I read it anyway, and it may not matter one way or the other, but I'd just offer you this. His selling agent in paragraph 98 was a construct, and he was just hypothesizing that the selling agent is an agent when advising. I don't think which he was entitled to do because that's a possibility. It's just a construct. I don't think he was necessarily doing any more than that.
So you mean he's not proceeding on the basis that a selling agent when advising will be an agent?
No, I think he's just assuming for these purposes that which he was entitled to do on a hypothetical basis, that he was, whereas in paragraph 165 he was dealing with reality, as it were.
So I'm not quite sure how it does fit together. If the theory is that when you're merely advising, you're not an agent, why would one suppose that property agents giving negligent advice would be within the scope of the agreement?
I think he was just assuming that they were an agent when giving advice because of the nature of a selling agent.
But why? How could that be? I mean, if the test of being an agent is such that when a solicitor gives advice is not an agent, how can a property agent be an agent for giving advice?
My Lord, I truly don't know. I'm just offering. It reads as if it's a sort of more of a construct in order to make a different point, but there it is.
Yeah.
And then, my Lords, you were taken to the particulars of claim, and in particular the amended particulars of claim, with a view to showing that my clients are still suing the Clyde Co as agents. And we went to the amended particulars of claim behind tab 22, and to various passages in there. There is an answer to Millennium Friends' submissions, as he took you to paragraph 25C on page A326. So far as causes of action are concerned, we do not make any claim or seek any relief on the basis that Clyde Co were agents of any of the claimants. That doesn't mean that, so far as the facts are concerned, there were occasions when they were. It's just that our case is not based on making a claim or seeking any relief on that basis. And we say that expressly because of the subject to this appeal, because of the judgment and order.
So you're coming back to your 1 day, 10-year type point. You're not. I mean, you say definitionally in support of your appeal. Well, they were never agents at all. But supposing that that's wrong in terms of your appeal, and some other analysis is called for, you're not suggesting there were no occasions when Clyde & Co, on this alternative approach, acted as agents, but you say you're not complaining about that conduct.
Exactly. I suppose there's an analogy here with the concurrent liability of a solicitor in contract and tort. You can make a claim against a solicitor in tort, and we do. We do it expressly in this pleading. It doesn't detract from the fact that it is a fact in the world that there was a retainer. But what we're relying on is a breach of a common law duty of reasonable care and skill in the tort of negligence, and that's what's pleaded. And that doesn't involve, we say, relying on the contractual agency, and we disavow any other reliance on agency. And we make that plain in that paragraph 25C.
Yeah.
And then turning to Mr. Curl's submissions on what affiliates means in a settlement agreement, he made a series of submissions to the effect that we are and have been flipping and flopping, waxing and waning, I don't know what the metaphor is, but moving around in our answers as to who we say, quote, and agents are on the construction of this particular agreement. And you recall he said that at one stage we were suggesting consultants, company doctors, and so forth. What we again ask your lordships to do when considering how to address these appeals and your judgments is to start every time with what these parties objectively would have intended by using these terms, affiliates and then employee. And that's the fundamental difference, I think, between us and my learned friends. We don't encourage you to look at these entirely in the abstract. And you've got our submissions on why we say the relevant circumstances have a strong influence on what the court should determine was the objective intention of the parties when using these words.
So just to be explicit, you say that these parties, in the context of this agreement, intended agents to refer to people who would have been employees, but for tax type considerations.
Somebody of that ilk, not external professional advisors, and certainly not the two persons whom they had discussed as potential targets for Mr. Schofield at a later date. Because if that's what they were addressing, they'd have done it expressly. And that is why we went to Gethsemane, not suggesting that there is any factual resemblance between that case and this. What we were saying is that having assessed what the relevant facts were, the relevant surrounding facts, the admissible facts, that enabled the court to say, well, surely, if that's what they meant, they would have said it. And that's what we say about these clauses. And in a sense, it's not relevant once we've identified the sort of agent that we say is covered. And we do say it is belt and braces. It's just adding "and agents" on the end as part of a genus of people who are not at all, obviously, external advisors such as Clyde Co. And once you realise what went between the parties, we say that they cannot have intended to refer to Clyde Co so obliquely. All within the definition of employee, of affiliate. Just making sure that I don't repeat any submissions that I've already made in response to Mr. Smith's submissions. Just give me a moment. Would you give me a moment? I'm reminded by Mr. Levy that I think I'm right in saying, it's my fault I've forgotten, that Mr. Curl is not pursuing his second round of appeal.
I think essentially that's right.
Well, the way he put it was that they said that as a matter of principle they thought they were correct, but in reality they accepted it had been overtaken by evidence.
Yes. So I wasn't proposing to respond on that. In those circumstances, those are my submissions.
Thank you very much. Mr. Carr.
Thank you, my lords. Sure enough, I did say that my gateway argument was the only way there could be certainty, yes, but that was hardly the primary way I put my construction argument on the settlement agreement. I said that it was the only way to bring certainty after I'd said rather a lot that was derived from what the settlement agreement says. And the certainty point was at the end, and it was essentially a cross-check by way of establishing the good sense of what the words on the page say. And my learned friend submitted that the judge was right, that parties still have to be an agent in respect of the activities that give rise to the claim. Now, in my respectful submission, and your lordship have my submissions on this, in my submission that isn't quite what the judge said, particularly at paragraph 98. He seemed, in my submission, actually to say the opposite of that, but to have overlooked it by the time he got to the end of his judgment. And my learned friend repeated his, I'm not sure whether it's a straw man or a red herring or what it is, but the suggestion that we are using the definition of liabilities to widen the definition of affiliates. Now, I reiterate that that's not what we're doing on this side of the court. We're looking at what claims are settled. And my Lord Justice Arnold, I would respectfully suggest, had him exactly right in Davis a few minutes ago, in that there are two questions. Who is an affiliate? And once you find out if they're an affiliate, you look at the scope of the release. That is exactly my case in a nutshell. And my learned friend submitted just now, you're only released insofar as you're an agent, and the definition of claims doesn't affect that. And in my respectful submission, the answer is, once you're an agent, you're released from all claims. But my learned friend posited the unlikely scenario that you have a solicitor who advises for 5 years, and on one occasion he acts as agent. And Mr. Davis suggested, well, that makes him an affiliate, and that's neither logical nor coherent. But it is logical or coherent when you consider that the scheme of the settlement agreement is to bring the claims to an end. It's to remove any litigation about these swaps and the loans relating to these swaps. My learned friend's paragraph 98 point, where he suggested that the selling agent was just a construct, and that the learned judge was hypothesising that the selling agent was an agent when advising. I would suggest that that's not what the learned judge appears to have been doing, but it doesn't matter, because one way or another, hypothetical or not, the learned judge is contemplating that someone is being released from a capital C claim based on negligent advice when they're an agent. And whether that's because they were an agent when giving the advice, or whether they are an agent when acting otherwise but are nonetheless released when giving negligent advice, it doesn't matter. Because someone here who is labelled an agent is being released from a capital C claim in respect of negligent advice. It doesn't help my learned friend, in my respectful submission, that he is not, he says, relying on such features as the retainer or the fact in the world that my client acted as agent in at least some respect to establish his claim. That simply doesn't assist him, because the fact that it's a fact in the world that that's what we were is enough in my submission. The real fallacy of my learned friend's position was identified or articulated by him right at the end of his submissions just now. He said, you've got to start with what these parties would have objectively intended by using these terms. No, you've got to look at what the settlement agreement means, what it reasonably means to someone having the background information available to these parties. It's about meaning of documents rather than intentions primarily. My learned friend suggested that it's unlikely that the parties intended to refer to Clyde Co in this respect, but that's essentially to start with the wrong inquiry, because the real inquiry is, what is this settlement agreement doing? It's settling all claims. And Clyde Co is exactly the sort of person who, when you're trying to settle all claims, i.e. all litigation arising from these swaps, Clyde Co is exactly the kind of person that you want to be brought in within the scope of released party. So it's not so much that they were thinking, right, who exactly are we trying to capture with this definition of released party? That's not what was going on. What was going on was, let's bring this litigation to an end. Clyde Co is captured, and that's exactly right, because that's the only way to bring this litigation to an end. May I just turn my back? Unless there's anything further which I may assist, those are our submissions.
In which case, thank you very much. Thank all of you for your submissions. As you would expect, we're not going to give judgment here and now. In the normal course, you, of course, will be provided with our judgments in draft for you to correct our typing and English, but not to re-argue the case. We'd be grateful if you would seek to agree the consequential order. If, in the normal way, there are points on which you disagree, we'd be grateful, please, for brief written submissions on those points, and we would expect to settle them in the order that we make. The other point to mention is that the practice now, as you'll appreciate, is for judgments to be handed down remotely rather than in a courtroom. But even supposing there were a hand down in the courtroom, then obviously there would be no need for anyone to attend. But thank you all very much.
Court rise.
Okay.